Looks like we are live. Good morning or good afternoon, everyone. My name is Usama Kaf at Fisher Phillips. Thank you for joining us for this panel discussion of how to select and vet your HR vendors in light of new and evolving privacy laws. Please feel free to submit any questions you have during the presentation in the Q&A panel, and we will be doing our best to try to answer all your questions during the presentation. If we're unable to get your questions answered during the webinar, we will follow up with you afterwards. This presentation is being recorded, and all the attendees will be receiving this week an email with a copy of the slides and a link to the recording. This panel is sponsored by Fisher Phillips and Vault Verify. Fisher Phillips is a national law firm specializing in labor, employment, and privacy law. I'm the co-chair of the firm's privacy practice group, and I'm joined today by my partner, Risa Borner, in our Philadelphia office, who is the founder of this privacy practice group and also the co-chair. Risa, please tell us a little bit about your experience in data security and privacy law.
Thanks, Usama. Yes, I'm the founder and co-chair of the firm's data security and workplace privacy practice group. I'm a certified information privacy professional with certifications from the International Association of Privacy Professionals, or IAPP, in U.S. privacy law and also in information privacy management. I've been working in the area of privacy and cybersecurity for several years now, and I help to counsel clients both in HR vendor management issues, like the ones we're going to talk about today, and in other areas, including data breach, consumer privacy compliance, and a wide range of other matters.
Now, Vault Verify is a tech-based HR software company that provides employment verification and income verification services to employers across the country. And on this panel from Vault Verify is Bill Roy, its president and chief revenue officer. Bill, why don't you tell us a little bit about your experience with data security and HR vendor management?
Yeah, thanks, Usama. We're pleased to be here and participating today. I've been in the HR technology space for over 35 years, and we really founded Vault Verify with the intention of creating a safe, secure environment for automating verifications. So we're pleased to participate and hope everyone gets a nice benefit from this today.
Now, we have teamed up on this panel with Vault Verify because many of our clients are facing very similar challenges in managing their HR vendor relationships, ensuring compliance with data security requirements, and maintaining control over how employee data is used and maintained by vendors. Employers in many states are facing an evolving legal landscape when it comes to data privacy. This includes having to hold your HR vendors up to scrutiny when they access or receive private employee information. But first, why don't we get all on the same page as to who we're talking about? What is an HR vendor? Well, it's a third party that you have a contract with, and the contract is to provide employers with certain services related to your employees or even job applicants. This includes, your payroll vendors, benefits vendors, employment and salary verification vendors, software providers that provide HRIS systems or any other kind of system that allows you to maintain employee records. Your HR vendors collect, use, maintain employee data. So any vendor that's a third party that fits into this category is who we are talking about today. Employee data privacy is really a hot topic today lately. Risa, why do you think that is?
Well, I think it's a combination of things. I think that, for many years, U.S. privacy law was really lacking from a high-level standpoint. There really has not been, and there still isn't, a uniform federal privacy law. And that's in contrast to what some other parts of the world are doing. For instance, the EU with the GDPR. There are many other countries that have broad privacy laws that apply across industries, including to employees in various parts of the world, but not in the U.S. And ever since the California CCPA was passed, I think states have been taking a hard look at this, and at the federal level, Congress has been taking a hard look at this and thinking about how to expand those rights and whether to expand privacy rights in the same way that the EU and other countries have. And that's led to the introduction of new legislation, which we're going to talk about, and increased regulation and requirements to manage the privacy and cybersecurity, applying to not only consumers' personal information, but also employees' personal information that's entrusted to employers. So I think it's the evolution of legal requirements, and not only the ones that are existing, but the ones that are being introduced and that are likely to pass in coming years.
Now, beyond changing legal requirements and expectations, there's also an HR aspect of this, right? There's employee expectations, and culture is changing. Especially as the world become more globalized, and people are more online and more aware of how their data is used. So, Risa, why don't you talk to us a little bit about what employee expectations are that we're seeing from a lot of our clients?
Sure. I think employees have a heightened sense of awareness around privacy. I think it's grown in the last couple of years during the pandemic, with employees having to disclose information that some of them may have considered private, relating to things like vaccination status and health information about illnesses. I think that employees are taking a closer look and thinking more carefully about the information they share. And I think that employees, like other consumers, they receive a lot of notices from retailers about data breach incidents. And there's some data breach fatigue, we'll call it, in terms of getting those notices from big retailers they may work with, or companies, where they've purchased, they've purchased products from. But when it comes to the data that they share with an employer, I think employees have a different expectation. I think they expect their employers to protect the information that they've entrusted to them. And, I think employees react more emotionally and, are more upset if they get a data breach notification from an employer relating to the information they've entrusted to them, because they just don't expect that.
So we're going to ask a polling question. How concerned are you about a data breach? You can take a couple of seconds to click on the screen to submit your answers. We're asking polling questions to make this more interactive and to make this eligible for continuing legal education and other HR certification certificates that can be provided. I'm just looking at the number as more people are submitting an answer. We're at 30%. I think the concept of data breach fatigue is pretty interesting. Almost everybody in the U.S. has had their data breached, right? And that's actually a bigger concern in the context of the topic we're talking about, because a lot of the data breaches occur at the vendor level, right? So it's data that you've entrusted to a vendor, and then the vendor suffers a data breach, and very often the backlash is against the company and not necessarily the vendor.
I think that's right. Yeah, and I think with employees, it's the same. They hold the employer accountable, even if the vendor, the HR vendor, is the one that had the data breach.
Okay, here is the result. 22% are very concerned, and 48.8% are concerned. So over a majority are either concerned or very concerned, which I think is in line with where things are. Now, this privacy legislation state map is currently on the Fisher Phillips website, and we regularly update it. But it reflects at least 5 states in red that have passed a broad consumer privacy law, several states that have introduced it, several states that tried to pass it this year, but it did not pass. But every year, this landscape changes. And one of the big changes with respect to employee data and HR vendor management is actually in California. For any business that is subject to the California Consumer Privacy Act and the California Privacy Rights Act that amended the CCPA, and a whole lot of employee-related requirements that take effect January 1st of 2023. And so the legal landscape for HR data privacy for employees is changing very rapidly. And so it's very important to keep abreast of that. Now, Risa, why should employers pay special attention to vendor management? Why is this an issue?
Sure. When employers hand off their data to a vendor, whether it's for payroll purposes or employment verification or some other purpose, employers still retain an obligation to make sure that the data is protected. And anytime you deliver sensitive data outside your organization, there's a risk. I saw a survey not long ago that said estimated about 50% of all data breaches in the last year came from vendors that companies retain for various purposes. And I don't think HR vendors are any different. We are getting a lot of, we've gotten a number of data breach matters in the last year relating to HR vendors, including payroll vendors, for instance. Some of them have been widely covered in the press. And so I think, that the cyber criminals that are looking for data, they know where it resides. They know that vendors, and in particular HR vendors, often collect a lot of sensitive information that they can benefit from. So they're constantly under attack. And, and the employer may have the derivative liability if there's a data breach involving the data they've entrusted to those vendors.
Now, Bill, have you been hearing any feedback from your clients on how their HR vendors are using employee data?
Yeah, it's a great question, Usama. So yes, we have. We've been hearing this for 8 years since we started Vault Verify. And I think it's a bit of a conundrum for employers. They need to outsource certain functions because they're not strategic. They're just sort of mundane tasks, but yet it's really important to find the right vendor. So I think there's a heightened sense of awareness, as you guys mentioned, that not only do my employees expect me to pay more attention to our vendors and my data privacy, but I think the employers themselves understand the liability attached to choosing the wrong vendor. So we're seeing a lot more of it. CCPA, GDPR, all of those are creating this heightened sense of awareness. And at least in our opinion, that's a good thing. We need to shed more light on this, and we need to protect the employee data.
So in HR, there's often this tension between two contrasting goals. And I think Bill shed light on that, where there's a lot of these mundane tasks that you have to outsource. And so a lot of employers rely to some degree, more than others, on outside vendors to provide to provide certain services related to employees. So there's always that need to give vendors access to your employee data in order to do business, in order to operate, in order to efficiently outsource things that you don't want to do in-house. But at the same time, whenever you give that third-party vendor access to your data, your employee data, you're opening yourself up to a risk of a data breach, and you're losing some level of control over the data because it's no longer in your possession, perhaps, or the controls are in the possession of someone else. So there is always that tension, right, between how do you make sure you outsource to HR vendors, but at the same time try to make sure you minimize the risk of data breaches. Now, Bill, what are some of the tips you would recommend for employers to navigate this tension that we're talking about?
Yeah, and again, great question. So I think increasingly, one of the big reasons we partnered with Fisher Phillips is just to help our clients and prospective clients understand data privacy in North America, where that's headed, and make sure they stay on the side of compliance. Selecting a reputable HR vendor, I mean, this seems like a logical thing, right? It shouldn't be that difficult, but some of the biggest names in the industry can also be some of the biggest offenders when it comes to utilizing data the wrong way or data breaches. As you said, we've seen a lot of that in the HR space because it is a big target. It's a well-known target. Beyond that, one of the things that we do with all of our clients is make sure that there's a firm understanding of what's in scope, what's going to be done with this data. And at the end of the day, I think it's a relatively simple principle of treating the data the way that employer would treat the data, in this case, if they were doing the verifications in-house. And again, not that difficult a concept, but for many of the vendors out there, we have to understand and be cognizant of the fact that they are making money from the use of this data. And that's unfortunate. So at the end of the day, one of the things we do, which is step 4 here, make sure you minimize that data send and store, we call it. Historically in our space, it's been a file feed. And that file feed would send all of the sensitive employee records every single week to the chosen vendor. There are better ways to do that. Fortunately, technology has come a long way, and it's not really necessary in most cases to do that anymore. So again, those are just some of the things that we talk to our clients and prospective clients about virtually every day.
These are great tips, Bill, and actually these 4 items create the framework that we're going to then now delve into. So we're going to focus a little bit on number 1, and we'll go through some of the data privacy laws that employers need to comply with before we jump on to the 2, 3, and 4. So Risa, why don't you talk to us a little bit about the actual legal requirements related to HR vendor management?
Sure. Well, as I mentioned earlier, there's no comprehensive U.S. privacy law that applies to all businesses. So when you look at privacy laws and what the regulations and obligations are, it's either industry specific. So for instance, the Gramm-Leach-Bliley Act, which applies in the securities industry, or HIPAA, which applies to health information, or that sort of thing, or it's a state by state, issue to look at. And of course, if you do business in a foreign country, like for instance, the EU, you also would need to look at something at the laws that apply there, like the GDPR. So just taking a couple of examples, I mentioned the Gramm-Leach-Bliley Act. There's a requirement there that applies in the securities industry, and including to auto dealers who offer loans to their customers. It requires protection of information that's in the possession of affiliates and service providers. So, and that was recent. A portion of the Gramm-Leach-Bliley Act was recently amended, the Safeguards Act, and it requires periodic assessments of service providers or third parties on a continuing basis. So, in other words, you can't just vet the vendor, and this is a best practice regardless of requirements, but it also is required by various privacy laws that do apply. It's not just a matter of vetting a vendor up front, although that is very important. It's also a matter of continuing to look at what the vendor's security practices are, because threats evolve, laws and regulations evolve, and you need to make sure that the vendors are keeping pace with those. So there's that. And then, if we look at the CCPA, for instance, which is the California law that I referred to earlier, the California Consumer Privacy Act, that's the first comprehensive U.S. consumer privacy legislation that was passed. Many states are looking at introducing bills that copy it. Some states have implemented consumer privacy laws. Not all of them apply to employee data, but as you mentioned, Usama, the CCPA does, and the requirements relating to employee data are going to expand. It imposes responsibilities on businesses for vetting vendors with whom personal information is entrusted. And again, the responsibilities are set to expand in January of 2023 to include employee data.
So let's talk a little bit about the statutory requirements, and then there's also the common law requirements. So I'll start off with the statutory requirements. To the extent that there is a particular law that applies to the employer, what is required? There's this concept of maintaining adequate security. What does that really mean? It's going to vary based on industry. It's going to vary based on a number of standards and factors. But one of the most important steps in maintaining appropriate security measures to protect your employee data is to properly vet the data vendors before providing them access to employee data, and then to regularly vet the vendor. So vetting the vendor includes asking for specific information, includes auditing them, monitoring their compliance with the security requirements, and so on. There's a lot of different things you can look at. You can start out by building a questionnaire or having a questionnaire that goes to your vendors to address data security. How are they protecting the data? Asking all the questions that you need to ask to rest assured that they are taking that they're only using the data appropriately and that they are taking all the proper precautions. Now, beyond the statutory requirements to conduct this kind of due diligence on the security measures of your vendors, there's also common law requirements. And there's case law, in many different states across the country, imposing on the employer a certain duty of care. Risa, can you explain what that really means for employers?
Sure, and I mean, employers have a duty to maintain the reasonable security, of the information that they're entrusting to a vendor. So, there can be a negligence standard applied in some instances to employers. There was a case that was widely publicized in Pennsylvania, Dittman versus UPMC, a couple of years back, that addressed that common law duty. Some other states have also imposed common law duties and requirements. These can lead to class action litigation, even separate and apart from the statutory requirements and the penalties associated with those requirements.
So in selecting vendors, some of the things that we would recommend that you ask for include asking for documentation of their security measures, includes asking about their security measures, what controls they have in place to access data, and this duty of care that Risa talked about. This includes conducting this kind of assessment, right? If you don't actually monitor and review your vendor's data security, and the vendor suffers a data breach, then there's at least an argument that you could have known about it by at least conducting some sort of assessment. And this comes up in the context of really any HR vendor, not just not just payroll, not just benefits, not just HRIS software providers, really all sorts of vendors. So I'm going to take a quick poll before we go on to more tips on how to select an HR vendor. Do you currently use a third-party vendor to verify previous employment and or salary history of your employees? Yes, no, or unsure? Please click on the poll to put your answer in. We should play some Jeopardy music. Now, in the context of employment and salary verification vendors, as well as really any vendor, you always want to ask vendors how are they using and protecting your employee data, and then what happens at the end of the relationship with that vendor. Are they still going to maintain that data, or are they going to delete it and remove it from their systems? And so those are questions that certainly would be addressed, and we'll go over some additional questions as well as soon as this poll is closed. All right. More than 50% of those who answered do use a third-party vendor for verifying employment and income. All right, so how do you select a reputable HR vendor? Now, HR vendors use employee data, and employers really must protect them. We've already established that. So how do you conduct proper due diligence? Some of the questions that we would recommend you ask, including asking about any history of a data breach. Has the vendor previously suffered any cybersecurity incidents? And asking about any measures that they have taken to prevent future incidents and protecting employee data. You also want to ask the vendor about their current security measures to ensure they are adequate to meet your needs. This may include requesting evidence of regular security testing, such as penetration testing and other security assessments, employee training programs relating to cybersecurity, and use of basic security protocols such as multi-factor authentication, encryption, audit logging, monitoring, etc. You can, like I said earlier, start with a security questionnaire to address those security measures. You also want to ask for and make sure that your vendors have an incident response plan that addresses what's going to happen in the event of a data breach involving your employee data. So if a vendor that you work with on the HR side suffers a data breach, what's the protocol? What's the plan? When are they going to notify you? What are they going to do? What's the plan for continued operations? What if it's a payroll vendor and you need to make payroll, you need to pay, or a timekeeping software vendor, and you need to make sure you're meeting your payroll deadlines? What are the contingencies? All of these things should be addressed in advance of anything happening, and that would be part of the due diligence that you would engage in reviewing your HR vendors. So you would ask for their incident response plan, business continuity plans, perhaps a disaster recovery type plan. You also want to look at whether your vendors are covered by a cyber insurance policy. In addition to making sure that your company has a cyber insurance policy, you also want to make sure that vendors that maintain or have access to employee data also have the appropriate cyber coverages. And then you want to evaluate the vendor's technology capabilities, determine whether the vendor can eliminate or minimize the transfer and storage of data by utilizing accepted API integrations, and whether the vendor seeks to bypass the employer and just simply collect data directly from employees to gain control over the data and then use it for purposes outside of the vendor relationship, which is a common issue with vendors where they end up collecting data directly from the employees. And there's a question about whether the employees really know that's happening and whether they've been informed appropriately. So certain vendors may require more vetting than others. This is why selecting a reputable vendor is important. But just because they're reputable doesn't mean that they've implemented all the appropriate security measures. But it's at least an indication, right? It's an indication, but it's not enough to hang your hat on that they are a reputable vendor. Depending on the type of data that you give access to your vendor, you will need to subject that vendor to heightened scrutiny if they have access to more sensitive data. Especially in California, where we now have a new subcategory of covered information under the CCPA called sensitive personal information. So for sensitive personal information of employees, you may need to apply a heightened standard and make sure that those particular vendors are subjected to a more rigorous review than others. So there's always a process for ranking your vendors based on the level of security that they of risk that they pose relevant to the data that they have. Bill, why don't you tell us a little bit about how whether you're hearing from your clients about their experience with HR vendors. I mean, there are HR vendors out there that might be using employee data of their clients in ways that the employer might not actually fully comprehend. What are you seeing as the top concerns that employers have about how vendors use their employee data?
Yeah, this is a really important topic these days. So we've discussed the fact that employers understand enhanced liability associated with their vendors. You talked through a lot of the good vetting areas, but have you really spelled out how these vendors utilize the data? There's a fair number of these vendors whose primary business is not necessarily just verifying employment and income. Their primary business is well outside of that, but it's tangential to obtaining the data in order to be able to use it for those other reasons, those other sources. So We always recommend and advocate to our clients that they spell out the actual reason for engaging that vendor, especially when it comes to verifications. Yeah, you can hide under something called permissible purpose, but permissible purpose from one vendor to another can be very different. Some vendors may consider things like pawn shops or collection agents permissible purpose, whereas if you were completing those in-house, I pretty much doubt most employers would consider that a consented employee verification. So definitely a lot more interest from clients, from employers to make sure they understand that scope of data. And even beyond that scope of data, have you done everything you can to minimize that HR vendor even having your data in the first place, right? So if we look at the funnel of all of the things you want to look at, have you checked off all of the boxes on ways to minimize that footprint outside of your chosen HRIS system of record? And then beyond that, have you determined what's in scope? Have you determined contractually what you'll do with that data, not only during the term of the contract, but after the contract? We're seeing this more and more. And some of the biggest names in the industry, as I mentioned earlier, can be some of the biggest offenders because they want and need that data to perpetuate their other businesses. So it really is important to understand what business is that vendor in primarily, and then certainly how do they intend to use our data, how are they going to store our data, and a lot of the items, Usama, that you went through. But I think at the start of this vendor selection, maybe it's more about the technology and what we call the art of the possible.
Before we talk about technology, I think it's important to link this back to compliance. This is not just about preventing data breaches. The data breaches are a very big risk, of course, when utilizing a vendor. And that's a big part of why you have to vet your vendor appropriately. But beyond that, there are going to be laws, depending on what state you operate in, where there are compliance obligations regarding what disclosures you have to make to your employees about how their data is used, where it's going to, who has access to the data externally, whether you have to identify the third party or at least identify a category of a third party with whom the data is shared. And then there may be obligations to disclose to employees whether their data is being sold. And this is a question we go through with a lot of employers who need to comply with the CCPA, for example. We obviously every employer is going to tell us we don't sell our employee data. We're not in the business of selling our employee data, which is to be expected. But you also have to make sure that your vendors that you're giving your employee data are also not selling your employee data without knowledge, without you knowing and your employees being notified. It's not that it's necessarily prohibited by that particular law. It's that there is a notice obligation that may arise if the employee data is actually being sold, whether by the employer or a vendor that the employer gave the data to under the auspices of providing services to that employer. So that's why this first question is very important. It's not just about whether they're using the data in ways you didn't know about, whether they're subjecting the data to further risk of a data breach. It's about whether they're using or selling the data in ways that you now have an obligation to tell your employees about. And if you don't know, your employees probably don't know either that this is happening. Now, Bill, can
and Usama, there's some great points to add on to that, Usama. You've raised a great point here because unbeknownst to a lot of employers, when you buy or lease an HRIS platform that does payroll, that does benefits, time and attendance, you sometimes get offered things along with, right, where they package it together. It's important to understand that not only did you buy that HRIS platform to handle payroll and time and attendance, but is there anything unseen there with that HCM platform, HRIS platform, may very well benefit from your sensitive employee data downstream. Are there certain agreements in place? Even white label or private labeled versions of certain platforms that benefit from it? Does the HCM benefit from selling your data? If I'm an employer, I look at that data that's in there, my HRIS data, time and attendance, payroll data, that's my data as an employer. But is that essentially being monetized to third parties in the form of services that seem free, but someone is benefiting from that? Maybe a little bit of a gray area. So I'm glad you brought that up. It's something that we're seeing more and more in this industry, where some vendors may look to buy some of those relationships. And I think employers have to be increasingly aware of that.
So we've talked about data breach risk, we've talked about compliance risk, and Bill brought up the point that there may be technology tools out there that help address some of these issues. So Bill, why don't you walk us through a hypothetical example of how different technologies vendors may have can actually address these issues and minimize the legal risks that we just identified.
Yeah, great question. So what we look at typically with our clients is what's the art of the possible? So what platform do you utilize for your HRIS or payroll platform? Are there legitimate APIs that can eliminate the need to send and store that data outside of your HRIS? What we fondly refer to as real-time APIs that allow a verifier to come to your platform. That integration enables a one-time use of that. Essentially, I can pull an employee record, deploy it back to that verifier, and the employer has full visibility to it. So that's one of the common ways that we eliminate that downstream risk of data breach. Again, if it's a smaller footprint, smaller target, less likely to be approached, which is a good thing in this case, a smaller target. But also, if the data is not there, it can't be breached. So we use a real-time integration that we strongly recommend. I think employers should be looking at. Again, it's not available with every HRIS platform, but where available, don't send and store your data every single week with another vendor. It's just not necessary in this technology age. And again, if better accuracy, up to the second accuracy, also reduces need back. So you can outsource to some vendors who receive this data on a weekly basis, and you're still going to receive a lot of verification requests because that data is not up to the second accurate. So there's a lot of benefits, including mitigating risk, to using these API integrations. I think the one caution flag around this area is those API integrations that may piggyback on an employee access that doesn't provide visibility to the employer. And those are relatively new to the market, but we talk to clients a lot about those types of things where you do have to have visibility to that data. The employer has selected a vendor. Let's use the technology properly. And in those cases, it really does minimize the liability of breach and mitigate the risk overall. So those technologies exist today. I would encourage those of you that do outsource to look at those, simply because if you're interested in reducing your liability, that's a key component of it.
Now, Bill, can you walk us through a hypothetical example of how this would look like?
Yeah. So we put this together just so people can sort of quantify what that is. This is our hypothetical 10,000 life company. You can fill in your math here, but the idea between what is historically acceptable in this space, which is creating a file or even use an API to pull all of that data into a vendor's platform and store that data just waiting for, in this case, let's say a verification to come in. If you sent 10,000 employee records every single week, that's over 500,000 records per year that are being sent completely unnecessarily. So when you think about minimizing that send storage, that gives you some ability to quantify it. And you can obviously fill in your employee count there, but it's significant, significant reduction in data liability. The other thing, we talked about some of the downstream uses of this data that might be well outside the intention verification of employment or income. And there are vendors out there that will seek to monetize this sensitive data 15 to 20 times per employee per year, utilizing it with sources that you would never fulfill in-house, and nor would you want anyone to utilize it with. And so when you look at that on this 10,000 life company, really you should probably expect about 25% of your population to require a verification in any given year. So that's 2,500 uses. If you pull those individually, then you reduce that send and store, but you also reduce the unintended use by maybe 150,000 uses per year, where someone is potentially monetizing your sensitive data. So it's an important aspect to look at and to really understand. Unfortunately, a lot of companies are not terribly forthcoming. One of the things we talked about in really looking at a vendor and evaluating is, can I see every single use of that employee data during the course of a year? If an employee called me and asked me, did Quicken Loans get our verification done? You should be able to look that up. Your HR payroll operations team should be able to look that and see it in real time, time and date stamped, no extraneous uses outside of those that are visible to you. And that's the kind of contractual language that you ultimately want to back it up with once you've done your initial, let's call it technology evaluation. And then finally, we've really talked a lot about the CCPA, CPRA rulings. I think that's driving a lot of employers to something that might be more secure, more visible, both to the employer and to the employee in terms of usage. But there are others like Privacy Shield and so forth, all designed to live up to both the employer and the employee expectations of data security and data privacy.
It's a great example, Bill, and it kind of shows visually, what is the actual exposure where you're giving regular and periodic and sometimes weekly access to a vendor to a whole lot of data unnecessarily. And this is a good way to think about, and this is not just for employee verifications, although we're using that as an example here as a model. But this concept, exists with respect to all other HR vendors. And any kind of access or vendor that requires regular access to employee data in order to provide the services for the employer. So it's important to take these concepts and address them with your vendors to see what sort of technologies give you these capabilities to minimize the risk and exposure. Now, back to Risa. Risa, I already talked about some of these, but why don't you address some of the due diligence tips that we would recommend to clients in vetting their vendors?
Sure, and I do think we've covered some of these, but just quickly to refresh on some of them, as you mentioned previously, you want to know what the vendor's history is in terms of past data breach or cybersecurity incidents, and what they've done to address those incidents to make sure that they won't occur again in the future. You want to ask the vendor and we've mentioned this as well, whether they share or sell the employee data for purposes that are outside the scope of the service that's provided to the vendor's client. and whether the vendor commits to delete all of the client's employee data after the end of the contract. So are they going to keep the data? You want to make sure that they're not, if you can do that. You want to get information regarding the vendor's current security measures to make sure that they're adequate to meet your needs as an employer. So that could include things like asking for evidence of regular security testing, penetration testing, other security assessments. Do they train their employees on programs that relate to cybersecurity? What about phishing simulation, for instance? Do they do that? And do they use basic security protocols? For instance, multi-factor authentication, encryption, audit logging, and monitoring, things of that nature. For those of you on the call who've been through a cyber insurance renewal process recently, you realize many of these have become baseline requirements to even obtain things like cyber insurance. You certainly want to make sure your vendors are employing, good practices as well. You mentioned, yep.
Well, I was going to say, now beyond these due diligence tips, Bill earlier also talked about how we need to address these issues in contract terms. So why don't we talk about the contract terms that you should be negotiating, especially for those of you that are subject to the California Consumer Privacy Act, where you're going to have to negotiate some of these terms by the end of the year to meet the January 1st, 2023 compliance deadline with respect to your HR vendors. And so, first is obviously the scope of acceptable data use needs to be defined in the contract. Data deletion requirements, that also needs to be addressed in the contract. And it shouldn't be just at the end of the relationship. It should be at the request of the employer. Upon request, the vendor would delete and provide a copy of the data, as well as if you're responding to a consumer request from an employee for deleting their data. And if you're obligated to delete the data, you have to go to all the vendors that have that data and make sure that they have contractually agreed to also cooperate with those requests. You want to address post-termination rights and obligations about retaining the data, including for archival purposes or other kinds of purposes that the vendor may try to put into the contract. You want to address that because you want to make sure you understand how are they going to use any kind of data they retain after the end of the relationship. Now, your contracts also have to address what happens in the event of a data breach, the vendor having to notify you, etc., compliance with privacy laws and specific laws that may apply, and addressing that contractually to make sure that the vendor, understands that even if they in their own business may feel that they are exempt from certain laws, you might not be exempt from it. So just because they might be exempt, well, you're not exempt as the employer, right? So if the employer is not exempt from the law, then you probably shouldn't let your vendors get away with saying, well, we're exempt from it, so we don't have to comply and we don't have to do that, right? So you want to go back to them and say, you have to comply with this because we do. It doesn't matter that separate from our relationship, you may be subject to some sort of exemption or exception under a particular law. So it's really understand where those exceptions and exemptions apply and where they don't apply. So there are many circumstances where your vendors on the HR side are going to say, we're exempt from CCPA, we're exempt from, this or that. And your response is going to be, well, we've determined we're not exempt. So guess what? As long as we're not exempt, you're not exempt for our purposes as well. And that's an important negotiating piece. In addition, you want to start identifying in your contract the actual security measures. What specific access controls do you want to put in there, and do you want to require them to implement? Right? It shouldn't just be implement appropriate security measures. You got to be a little bit more detailed than that. Finally, an item that's not in here is the right to audit, which is an interesting one. It's a one that often results in tension in contract negotiations with vendors. Obviously, on the vendor side, vendors are going to tell you we don't want to accept, contractually the right to audit. because it's intrusive. It means they have to show you under the hood every year, and you have to go through their systems and review actual evidence of compliance with the law, compliance with the contract, as well as evidence of security measures, beyond just simply believing their word and taking their word for it when they show you their particular certifications or answers to a security questionnaire. And so this right to audit is going to become a point of conflict in negotiations between vendors and employers. The employer wanting the right to audit, sometimes in order to comply with the law, and the vendor wanting to find every which way out of the legal requirement to be subject to the right to audit, because now they don't want to have thousands of their corporate customers that are employers suddenly subjecting them to an audit every single year, which can be expensive and burdensome. Right, so this actually comes up in the context of the CCPA and the CPRA, where technically it doesn't, if you read the statute or even the proposed regulations, technically you're not required to contractually have the right to audit. It is recommended, strongly recommended, that you have the right to audit your vendors contractually and that you actually engage in that annual audit. However, if you read the most recent proposed regulations under the CPRA that were issued by the California Privacy Protection Agency in June of this year, there is a statement in there, there's a section that essentially would deprive the employer of the ability to utilize a defense that is otherwise available under the CCPA if you don't actually audit your vendors. So if you don't audit your vendors, and the vendor suffers a data breach, then the otherwise available defense of I didn't know and I shouldn't have known would no longer be available to you if these regulations go into effect as proposed. This is huge because prior to this, there is no liability if you did not know or should not have known, did not have reason to know that the vendor had failed to implement reasonable security measures. So this is where asking the questions and getting information back would be enough to hang your hat and say, I had no idea. I asked them, they told me everything was fine. I asked specific questions, and they said everything was okay. And that maybe you saw their certifications and you thought everything was okay. Well, now if you don't actually engage in the audit, which is an annual audit of your vendors, looking under the hood, so to speak, then you may lose that defense of being able to say, I didn't know, because not doing the audit would mean that you could have known and could have discovered it had you conducted the audit. So that's going to be a very important point of tension in negotiating these contracts moving forward, is making sure you try to add in the right to audit in your contract and actually engaging in that audit. That's going to become a point of contention. Now, Risa, why don't you tell us finally here before we close, what are the consequences? A lot of the folks on this call may not necessarily be the decision makers, or so you might need to go to the board or the CEO or someone who needs to make a decision. Why prioritize HR vendor management? Why should we spend money on vetting our vendors? Why should we spend money on these annual audits of our vendors? What's at stake in terms of actual monetary exposure?
Sure. Well, as Usama mentioned earlier, the risk is not just data breach, it's also violating statutory requirements in terms of vendor management. And there are different penalties and different consequences that employers can suffer if they don't meet the requirements, regardless of whether there's a data breach. But under the CCPA, for instance, violations of the CCPA are subject to enforcement by the California Attorney General's Office, which can impose civil penalties of $2,500 for each violation, or $7,500 for each intentional violation of the CCPA. That's just one example. For a company that has data of EU residents, under the GDPR, the penalties can be very steep, up to 4% of global revenue, for instance. So there are different fines, that are permitted by within the U.S. by different statutes, and they do vary. But those are some examples. And then there's litigation. There's the risk that you'll get sued if your vendor has a data breach, for instance, that you will get sued by a class of your employees. And that doesn't just entail legal fees and damages, but it's also a drain on time and resources of the company just to defend the litigation, and those litigation matters can go on for years. And then there's also the potential for harm to the public image of the business. How will people feel about your business if it's publicized that you allowed your employees' data to be leaked, or the data was subject to a breach event or a ransomware attack because you entrusted it to a vendor. And there's a potential in all of these circumstances that that what you have done to vet the vendor, what you have done to make sure that the vendor has adequate protections, will be reviewed and assessed. And depending on how robust your investigation has been, you may suffer the penalty, if it's held to be inadequate.
To put the statutory penalties that Risa mentioned in perspective, let's kind of take a hypothetical. And we talked earlier about whether a vendor is selling your employee data. Let's say that you could have discovered and would have discovered through an audit and assessment and other kind of mechanism that an HR vendor that is getting your employee data is actually selling that data and using it in ways outside of and sharing it perhaps in ways that would constitute selling under the CCPA. If that ends up in an enforcement action, and let's say you have 1,000 employees in California, that's 1,000 employees that did not receive the appropriate notice about whether their data is actually being sold. And the employer is not the one selling the data, but the employer is responsible for the data. It's the employer gets the data, they're the controller of the data, and the vendor is not supposed to control the data. They're just simply the processor or a contractor that has access to the data in the course of providing services. And so you're supposed to know what your vendors are doing, because you may have an obligation to notify the employees in your notice that their data is being sold, and also give them the opportunity to opt out of that sale if their data is actually being sold. So if you're not telling employees what you're required to tell them, then that could be a violation for every employee who did not receive the appropriate notice. 1,000 employee example, multiply that by 2,500, and you do the math. That's a huge potential exposure just on that alone. So in closing, we recommend that you monitor new legislation. The law is changing constantly. There are regulations that are going to be proposed in a number of states that have adopted broad consumer privacy laws. There's the proposed regulations in California that are currently being debated and are going to continue to change. And then there's new legislation that keeps coming up every single year. So we recommend that you monitor, you visit our website and look at the legislative map that we have on the consumer privacy and the data security privacy page. Now, beyond that, Bill, why don't you give us some of your closing remarks and recommendations?
Sure, thanks. So obviously, number one is to minimize that data footprint outside the HRIS. We talked a lot about that. It's certainly possible to do that, sometimes easier to do that. So in most cases, there's no excuse for not minimizing that liability to your organization. The other thing, and Usama talked quite a bit about the audit capabilities. Well, in many cases, there's a lot of visibility that serves as an audit, right? What are you doing with my data? I want to know, and I want it contractually bound that I have visibility to every use of that data. So again, that's kind of a spot check audit, if you will. And so we highly recommend that whatever vendor you choose for your HR services, that they give you visibility to where that data is, what was reported. And again, that's going to help you tremendously with CPRA as well as CCPA. And then, we encourage this too. Read the contract. The contract should be clear, indisputable language. And yet we see so often that Some of the clients that are looking to come off of another service, there's so many gray areas there about what really happens with the data. They argue about deleting it. Make it clear, easy to use. If you don't have counsel and you want to use counsel, obviously, we feel the need to do that as well. And Fisher Phillips is a good resource, but certainly pay attention, especially to any of those gray areas, the gotchas that we call it in contracts that, really gives them a little bit of gray area in terms of using data. Don't allow that to happen with your sensitive data. It's just not necessary. So those are some thoughts. Certainly appreciate the opportunity today. And Osama, I'll turn it back to you.
Thanks, Bill. Risa, any closing remarks before we finish?
Just to emphasize what you mentioned before about making sure that you are adequately vetting your vendors and that you're aware of what the legal requirements are for doing that and for monitoring compliance with requirements going forward during the course of your relationship. I think that's really important.
All right, and with that, we will close. Thank you all very much. Again, this was recorded, and all attendees will be receiving an email with the slides and with a link to the recording. And if there are questions that we were unable to get to during the presentation, we will send you an email follow-up, hopefully this week, addressing with answers to those questions. Thanks, Risa. Thanks, Bill. See y'all later.